Looking forward to hearing what you have to say.
Thank you, Sir Robert. Good morning. It's a pleasure to return to Stavanger for this conference. I want to start first of all by recognizing Sigurd Robert and Carolyn for organizing such an important event on Arctic safety. And second, I want to congratulate our host country, Norway, on their 39 medals at this year's Winter Olympics, setting a new record for the most medals won by a country at a single Winter Olympics. Bravo. I will note that Canada won 29 medals, and we're very envious of your medal count. So my outline for this morning, I'd like to give you a jurisdictional overview, and then look at activity in the north, talk about licenses that are active and the moratorium that was announced in 2016, and then look at an Arctic review that the National Energy Board did a few years ago, and forward looking towards some regulatory reform that's on the way, including some expectations around same-season relief wells. We'll talk a little bit about some research and development that's on the go, and then provide time for some questions. So if you're not aware, the Canadian offshore has 3 offshore regulators. I work for the National Energy Board. So our jurisdiction in the offshore area and some onshore is in this yellow area here, and British Columbia, off British Columbia, and parts of the East Coast. This area here, it might be a future offshore petroleum board adjacent to Quebec. We also have on the East Coast the Canada, Newfoundland, and Labrador Offshore Petroleum Board and the Canada, Nova Scotia Offshore Petroleum Board. The National Energy Board is entirely federal. The 2 East Coast boards are a joint management between the federal government, Canada, and the province of Newfoundland and Labrador, and for the CNSOPB, Canada and Nova Scotia. So these are the jurisdictions when it comes to exploration and production. We'll talk about the licensing separately. So the scheme here, and the reason why there's joint boards here, is that typically outside a certain limit from the province, the federal government would own the resource revenue. Accords were struck between the province and the federal government that really saw the cash from oil and gas development go to the province. But in exchange, there is, I'll say, a national, provincial oversight and management of that resource. I will mention that although the National Energy Board regulates oil and gas activity in the north here, I'd say 90% of our mandate is actually pipeline, interprovincial and national transmission pipelines. That's the biggest part of our mandate. With respect to actual production in the Arctic, there isn't any in Arctic being bound by 60 North. There is no offshore production in the Arctic at this time, but there are 2 onshore projects. One that's been around for about over 90 years is the Norman Wells production facility operated by Imperial Oil, a majority owned by ExxonMobil. That produced about 10,000 barrels a day, and oil travels down by pipeline into northern Alberta. And then there's a small gas field just outside Inuvik that provides heating fuel for the town of Inuvik up adjacent to the Beaufort Sea, but it's onshore. Now I want to talk about licenses. There are, as you can see, several licenses that are active in the north. I'll review the National Energy Board jurisdiction first, and then we'll look at the offshore petroleum boards. So there are currently 15 exploration licenses that are active. There are 48 significant discovery licenses that are active in perpetuity. They don't expire. And right now in the National Energy Board jurisdiction, there aren't any production licenses except for onshore. compare that to the Newfoundland board, and this border you see here is the 200-mile limit, but in fact the jurisdiction for the Newfoundland board actually extends also out to the edge of the continental shelf. So they've got 28 exploration licenses, 56 significant discovery licenses. Again, our significant discovery licenses don't expire, and 12 production licenses. We'll look at which companies are continuing to produce in a couple slides. And here, the Canada-Nova Scotia Offshore Petroleum Board, 6 active exploration licenses, 33 significant discovery licenses, and 11 production licenses. So just to give you the highlights of the 3 land tenure instruments, exploration licenses, which I mentioned there's 15 in the offshore area, or in the Arctic offshore area. These are 9-year terms divided into 2 periods with a drilling requirement in the first period of the term. And these do expire, and there's no mechanism in law to actually extend the license. So after 9 years, the license expires. And then we have significant discovery licenses. Again, I mentioned they don't expire. However, since 2007, the offshore boards and the federal government of Canada started a rental cost, escalating rental cost framework, where up until 2007, you could hold the license and it actually didn't provide any cash flow for government. It just remained reserves on the books. And seemingly there's no incentive then to develop the license because you'll never lose it and it doesn't cost you any money to have it. So the scheme of escalating rental licenses, or rental costs, were about every year paying more and more. And after 20 years of holding a license, you might pay up to $1 million and then go up from there as well. So you still don't lose the license, but there's an incentive to actually develop it because you're paying rental costs to hold those licenses. And then a production license, they're issued on a 25-year term. They expire after 25 years, but if you're still in production, it automatically renews, so you don't have the risk of losing the license. And I will mention, what does it take to call something a significant discovery? The test is quite low. There's a long definition, but I'll just hit the highlights and say that you have to prove that there's a existence of hydrocarbons and that it has potential for sustained production. So a fairly reasonable test to make. Like I said, there's about 150 significant discovery licenses offshore Canada. So I want to flick through some of the, zooming in on the more active areas in the Arctic when it comes to licenses. And this is an interesting one, the Beaufort Sea. Over the years, I've got the statistic here. We drilled approximately 93 wells over the years in the Beaufort Sea. These pink blocks are significant discovery licenses. Again, existence of hydrocarbon that can sustain production. And these are the active exploration licenses. These, I think the last one expires in 2023. And I'll jump into these 2 licenses here, EL 476 and 477. These were awarded through a bidding process back around 2010. Imperial Oil Resources Venture Limited were the ones that were awarded those blocks. And shortly thereafter, around that time, of course, Macondo happened. And of course, the commercial price of oil also had an effect in the coming years, such that in 2015, Imperial Oil sent a letter to the National Energy Board saying that they'd suspended all regulatory work, and they were requesting the federal government to reconsider this 9-year license term, especially given the commercial environment they were dealing with, and actually wanted it to go to, they suggested, 16 years and retroactive to the issuance of the licenses. The basis for that was they needed more time to undertake the necessary technical studies and develop the technology and processes to support responsible development. And that letter came after our Arctic review. I'll speak of the Arctic review in a bit and the expectations around season relief wells. So in July 2015, shortly thereafter, the then government initiated a review of what's the right answer for license terms in the Arctic in particular. And no decision has been made on the study. The study recommended that, yeah, we should indeed consider 16-year license terms, but the government hasn't actually made a decision about that. More to come again on with the new government on their views on license terms. In the high central Arctic, there are about half a dozen significant discovery licenses. And most of these were held before the merger by Petro-Canada, and now they're held by Suncor. Mostly gas here. And then in the eastern Arctic, so here's Greenland. There's one significant discovery here held by Husky Oil. So here's a summary of the activity today in the offshore areas of Canada. And each column is by regulator. So I work for the National Energy Board, the NEB, and things are fairly quiet. There is no exploration seismic currently. There's no exploration drilling, and notwithstanding there's some onshore production, there's no offshore production in the off British Columbia, up in the Arctic, or in the other areas of NEB jurisdiction. Our most active region of Canadian offshore is within the jurisdiction of the Canada, Newfoundland, and Labrador Offshore Petroleum Board. This year, they anticipate several 2D and 3D seismic programs. Husky is drilling an exploration well, a White Rose A24. And there are 5 production projects on the go. The first production project being Hibernia, and the most recent being Hebron. Canada Nova Scotia Offshore Petroleum Board, there's no exploration seismic anticipated for this year. There is a deep water exploration well by BP, the Scotian Basin, right on the slope. And they have 2 gas fields. These are all oil fields. The offshore fields are oil in Newfoundland. Off Nova Scotia, they're gas fields. So we have Deep Panook and Sable offshore, and they're scheduled to commence decommissioning and abandonment of both fields in the next 2 to 3 years. So in 2 to 3 years, there isn't any production foreseeable, obviously looking at development plan horizons and how long these things take. No production off Nova Scotia within 2 to 3 years. And depending on how this exploration well goes, there may be more to come for Nova Scotia. And I think White Rose A24 was about to spud imminently, pretty close to spudding. So, you may have heard of the Arctic offshore oil and gas moratorium. This was a moratorium announced both by the Prime Minister of Canada and the President of the United States back in December 2016. So this was an indefinite moratorium on new rights in the Arctic offshore, and tested whether or not that moratorium should continue every 5 years through a science-based review. Now, this is about no new licenses. Existing rights were not affected by the moratorium, so all those significant discoveries and exploration licenses could proceed through normal authorization processes. Now, of course, they need to consult. In this case, they didn't consult before the decision. They decided to consult after the decision, including existing rights holders. And that consultation began roughly 4 months later, in April 2017. in that consultation was more discussion about license terms and the extension of those license terms, in particular in the Beaufort Sea. So this is the moratorium area. I might get this slide pulled from the deck only because yesterday I read the fine print that says map is for illustrative purposes and internal use only. So you didn't see this. But there's no secrets on here. You can see the significant discoveries and exploration licenses and some old permits. Here's the jurisdictional bound. So any licenses issued within this boundary is a federal department that really focuses on the north. And then within this boundary is Natural Resources Canada. And you can see here, this is north of 60, and this line here shows that the Newfoundland board does creep up into north of 60. Of course, you see winter sea ice that comes down into northern Labrador. This is Labrador and along here. So this is the extent of this moratorium that was announced in 2016. So these are the key messages from government. This decision was not a National Energy Board decision. This was a government decision. So Canada remains committed to ensuring that oil and gas activities planned for Canada's Arctic waters will only occur if the highest safety and environmental standards can be met. Now, this is the acronym, for the new agency, but it's still the Government of Canada. Working with territorial governments. So Canada is broken up into 10 provinces and 3 territories. So these are the territories that touch Arctic waters. Yukon Territory, this is the Northwest Territories here, and Nunavut is the balance of the offshore area in the Arctic. So with this review is also an implementation of regional strategic environmental assessments related to oil and gas activities. So that's there's one SEA, Strategic Environmental Assessment, that's looking at the Eastern Arctic and the Nunavut waters, and then there's one focused on the Beaufort Sea. And these strategic environmental assessments, this one should be done in 2019, and the one over here should be done in 2020. Both of these reports are intended to inform the decision-making on how to proceed. So they've completed their consultation. The next step is to go to Cabinet. So I mentioned the strategic environmental assessments. Next, they'll be seeking policy direction from Cabinet on how to proceed, in particular about the license extensions, which is important to the operators. And the moratorium, again, will be reviewed every 5 years. So that's the current state on the moratorium. Now we'll go back shortly after Macondo in 2010. The National Energy Board, reflected on that incident and said, let's have a look at what responsible development looks like in the Arctic. So they initiated an Arctic drilling review, which is a lot of consultation in the north with the northern communities, as well as scientists and other stakeholders that had some knowledge and information to share. And at the end of the review, the NEB issued a report. It's intended to send a message to industry on what the NEB's expectations are regarding responsible development and offshore drilling in the Arctic. So in particular, some words on same-season relief wells. There is the policy that requires same-season relief well drilling to kill an out-of-control well in the same season in order to minimize harmful impacts on the environment. The NEB will continue to require any company applying for an offshore drilling authorization to provide specific details on how they will meet this policy. An applicant wishing to depart from this specific requirement must demonstrate how they would meet or exceed an equivalency. So at the same time that we say same season relief well is required, we do leave the door open for creative and innovative solutions that achieve the same outcome. Not sure what those would look like. Certainly this is what Imperial was evaluating when they asked that, when they paused their application process and requested a license extension, to really understand what those options might be for them. And then it'll be up to the NEB to, on a case-by-case basis, determine whether or not the proposals by industry really met that intended outcome for a same-season relief well. Note that it's not a statutory requirement for a same-season relief well, but it's a matter of policy. Next, I want to talk about regulatory renewal. Many of the regulations that the three boards work with go back over 20 years. So it's time for a refresh. A lot of prescription in the existing regulations. So this initiative is called the Frontier and Offshore Regulatory Renewal Initiative. So the scope includes all the offshore as well as onshore in the Arctic. Partnership, the government holds the pen. The offshore boards and the National Energy Board provide expert advice to government on the shaping of those new regulations. So the objective is to modernize the regulatory framework in order to maintain Canada's high standards for safety, environmental protection, and management of the resources. So these regulations will also include the use of spill treating agents. Along the way, these are harmonized, 5 regulations or more, harmonized into one cohesive regulation. They've gone out in packages for informal consultation with industry and stakeholders. The last of those packages went out in the last few months. The formal step of creating regulation is when it gets published in a government document we call the Canada Gazette. That's expected to be in about a year's time when it'll go out for formal consultation. So this is not law yet, kind of like these amendments to the BSEE rules. These are proposed, and the public has an opportunity to comment on those. To highlight some of the changes, some new explicit things in there is the requirement to foster a culture of safety. So it's great to see safety culture. We all know that culture plays a big part in the safety of offshore activities. As well, a safety critical element approach, really looking at those systems that mitigate those hazards from major accidents, or in their absence could result in a major accident. And change management. So some of the management system requirements were also strengthened. There were management system requirements. They've been strengthened in areas of goal setting, for example, incident investigation and communication and records management. The certification process for installations. So we don't have a verification scheme. We have a certification scheme by certifying authorities. There'll be a new step to identify the design basis and the certification plan upon which the installation will be certified. A shift in focus towards identifying hazards that may lead to a major accident, so the safety case approach that you folks are probably quite familiar with, and updates to conflict of interest clauses when certifying authorities are also in the business of engineering and design, and how we work through that. And the proposed changes in the when it comes to well containment and control is operators must be able to, as promptly as possible, deploy measures to stop the flow from an uncontrolled well as soon as the circumstances permit. So, we've seen the development of capping stacks. Certainly that's an expectation of the offshore petroleum boards to deploy capping stacks. So it's finding its way as a subject in our regulations, our future regulations. Operators must demonstrate how the objective of deploying measures and controlling the well can be met through the contingency plans, the adequacy of those measures, and they must have access and the ability to promptly deploy these source control systems. And some of the specifics in the contingency plan, they have to submit a description that includes the subsea containment and capture equipment, how they're going to manage a suitable relief well arrangement, all the contracts required to achieve that, the schedule and plan for the mobilization of all these different response tools, and details around the support systems and equipment like vessels and ROVs and that sort of thing. Last thing I wanted to touch on was some, I'll call it R&D work or some study work being done. This is with the International Regulators Forum. And the IRF is a group of regulators that are focused on oil and gas development from a safety perspective, which the NEB, BSEE, the 2 offshore petroleum boards, several other jurisdictions are a part of. So back in 2015, there was a project that was initiated regarding safety culture. A working group was established from a few of the country regulators, and the idea was to identify key cultural elements and indicators that impact process safety and performance and contribute to major hazard incidents. So a phased approach, talking to IRF members on safety culture indicators, and then we had culture experts provide some feedback on which of those were most valid. And phase 3 was a survey of industry associations on the most important indicators. So the final report and recommendations were tabled last year at the 27 AGM of the International Regulators Forum. And you can find the report on the IRF website. I'll also mention, put in a plug for the next IRF conference is in Aberdeen in June, associated with the Piper Alpha conference, where there'll be a workshop on these indicators if you're interested. So thank you for your time, and I'll take any questions if you have any.
Thank you very much, Keith. While the audience is preparing all the questions they have for you, I have one in the meantime. As a regulator, we're always very interested in how the other regulators are moving. Could you tell us a little bit more? How are you going to make a balance between a prescriptive approach using codes and standards or moving towards performance-based requirements?
So, like many things Canadian, we like to sit on the fence in that area. So we take a hybrid approach. I'd say we lean more towards performance-based now in what's being proposed for the regulation. So you will see some prescription in there, like the MOJU code would be prescribed, that would need to be followed. But you'll see many of the, I'll say, design standards as it pertains to installations taken out of the specifics of the regulation. Those things tend to find homes in find a home in our guidelines, where in our guidelines we'll describe an acceptable means of compliance, the acceptable codes and standards. Regulations, some of those have been over 20 years old. It takes a long time to develop regulations. In the goal-oriented world, through guidelines, we can keep pace with technical developments and evolution and keep pace with giving industry our expectations of what reasonable looks like in the use of codes and standards. So with the use of less prescriptive regulations, but I'll say robust guidelines, we can ensure that the best approach is used.
Yes. Okay. Thank you very much. Now, questions from the audience. Catherine.
Hi, Catherine Yara-Nilsson from Statoil. Thank you again for another very good presentation. It's a very specific question. There was an incident a few months back offshore Newfoundland relating to a disconnect or non-disconnect. And that, as we understand, was related to decision making. I'm wondering, as part of this discussion about prescriptive versus risk-based, is this type of incident going to be addressed by can you manage this type of risk by the proposed update in regulations, or would you be proposing to take other measures through the regulators to address that?
Well, my colleagues from the Newfoundland Board are here that can speak to the specifics, but if I can speak to the generalities, and having worked on a floating installation off Newfoundland, the Terra Nova FPSO, We had contingency plans that, well, first of all, were disconnectable as an FPSO, and had contingency plans around ice management and how that FPSO monitored for icebergs as well as pack ice. There's certain design criteria for that, working in that kind of environment. Through those contingency plans, we identified T times, how far away things have to be before we start escalating our progressive shutdown, flushing of flow lines, and disconnecting of the FPSO. So, you know, are those specifics addressed in regulation? Not specifically, but it is, you know, ice is a known hazard. So through the studies, it's expected that operators will have plans for ice encroachment and implement those plans. And those plans are, there's very few, I'll say, prescribed filing requirements for a drilling program or production program. But things like safety plans, environmental protection plans, and contingency plans are on the list of things you must provide. The rest is at the discretion of the board. So these contingency plans have to address major hazards. Ice is a major hazard. They had plans, we had plans as the Terra Nova FPSO for how we dealt with that. And the regulator expects us, having accepted that contingency plan, that we follow them. I guess I had the benefit of not being too close. I can provide some speculation. You can probably corner Paul Alexander, who's the Chief Safety Officer, later if you want. It seems to me that it was a case of an operator who had a plan, didn't follow a plan. So the goal is know your hazards, plan for contingencies, and execute the plan. The regulation says that. I'm not sure they did that. So I think that's the path to what a safe operation looks like, and when that's not followed, puts people at risk and results in consequences. Does that answer your question?
Partly, we can take it later.
Okay, thank you.
Is there anything you may like to add, Paul?
No, I think he gave a very good reply. Very good.
Paul liked that answer. Yeah.
Okay, we've still got time for a couple more questions.
Yes.
Yep, great.
Graham Dick from Reflect. One of the areas that you were looking at for improvements on was conflict of interest with the certifying authorities.
Yes.
Is that, what sort of problems have you had with that in Canada that you see that as an area that you need to focus on?
Well, there's in our law there are 5 agencies that can be certifying authorities: Lloyd's Register, DNV, GL, who've now merged into one, American Bureau of Shipping, and Bureau Veritas. So these are classification societies that can also play a certification role for the certificate of fitness for an installation. So where it gets tricky is when you've got big certifying authorities that do engineering and design and do certification. So it's about how we ensure that the ones, because the idea of the certifying authority is an independent, fresh set of eyes that looks at design appraisal as well as ongoing fitness, not just the initial certificate, but ongoing fitness. We want to create enough separation that they aren't certifying their own work, and that the certifiers aren't also too close to the designers, and that's the kind of conflict that we want to avoid. It hasn't come up much, but it's come up enough that we saw the opportunity to provide some clarity in the regulation.
Okay, thank you.
Another question? Hugo? Down there.
Hugo Halvorsen, Working Together for Safety. In one of your slides on regulation, you used the term, I think it was something like, as soon as circumstances permit. And I'm thinking that's subject to a lot of interpretation, and circumstances could be very, could have many different aspects to it. So what kind of discussions have you had, and before you ended up with such a phrasing? Was pros and cons of writing something like that, I would imagine.
Well, it obviously requires a fair bit of study by the operator as to what's reasonable and review by the regulator. As you can see, we've got very diverse territory that the regulation covers. both onshore in the Arctic, offshore in the Arctic, on the East Coast, oil, gas. That provision applies to all of it. So it's very much, I think, in the context of the risk. So if you're dealing with drilling in the Arctic and coming into the ice season, what quick looks like or quick enough looks like is different than the risks of a gas well off Nova Scotia that may have very little liquids and doesn't present the environmental risk, certainly with, I'll say, light hydrocarbons flashing off in the water versus a heavy oil heading out under the Arctic ice. So it's very much context sensitive, and the benefit of early engagement between the company and the regulator allows that setting of expectations of what the regulator thinks is reasonable and what the operator thinks is reasonable, and working towards what's in the public interest. So because of the diversity of where these regulations are applied, the answer is it depends. And it depends works its way through not only the environmental assessment process, because a lot of the environmental assessment attention not only about the time of year you do the activity, but the impact of major events and worst case events really informs the timeliness and the sensitivity of timing, such that in some circumstances we may want a capping stack on the beach 2 days away from that well. In other circumstances, a gas well that has very light hydrocarbons and not much of them may not have that sense of urgency. So it gives everybody the flexibility to do the right thing, and early conversations allow us to establish what the right thing looks like.
Mm-hmm. I think we still have time for a few more questions, if anybody has one.
Yes, my name is Øyvind Jonassen, Norwegian Ship Owners Association. Thank you for the presentation. You mentioned the importance of suitable guidelines to fulfill the goal-based regulations. And I wonder what kind of role does the National Energy Board have in the development of these guidelines?
So the offshore boards have several guidelines. Waste treatment guidelines, of course, drilling and production guidelines, safety plan guidelines, environmental plan guidelines, offshore standby vessel guidelines. So to varying degrees, the National Energy, I'll say that the East Coast boards are authors of all of them. National Energy Board participates in some of them. As you can see right now, there isn't a lot of activity in the north. These guidelines are meant to cover all the jurisdictions, and the peculiarities of the Arctic need to be recognized. And the current drilling and production guidelines as they're written today don't have a lot of Arctic content in them. Moving forward with these new framework regulations, the National Energy Board will be participating in the development of those regulations. Nevertheless, whether we publish them or not as the National Energy Board, they're out there as a set of guidelines that are probably 80% applicable to the Arctic, again, tailored to the actual circumstances. But the regulation is the statutory instrument, and that's where the legal obligations lie. We would even though our logo isn't on the cover, we would draw on those guidelines to have the conversation with an operator. And certainly, as we develop regulations with the offshore petroleum boards, and in the future work more closely with them on guidance, it's our intention to provide the fairest, consistent set of expectations for a company, so that as they jump from drilling well in Nova Scotia to Newfoundland up into the Arctic, that it looks like there's a single unified approach and appreciation of risk and how that oversight happens. We're constantly talking amongst each other, even notwithstanding the activity in the National Energy Board jurisdiction, continue to work together with the offshore petroleum boards to have a whole of Canada solution and approach to these kinds of things.
Mm-hmm. Okay. One more question. Okay. Everything seems to be very clear.
Oh,
Thank you
very
very much.
Thank you, Sir Robert.
Thank you.
Pleasure.
Thank you. Just